Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Hello, and welcome to our podcast. This is Susan Stevens, and I'm one of the three authors on the podcast today that authored the ABA Sears book, Wetlands Law and Policy, Understanding Section 404. So we thought it'd be good for us to get together today and explain a little bit about Section 404 and some very recent developments in the field that even post-date that book, which is available from ABA Sears on their website. A little bit about myself. I have been practicing wetlands and natural resource law for over 30 years in Florida at both the state and the federal level. And I'll turn it over to Diana Connolly for her introduction.
Hey there. Oh, it's great to be with you, Susan and Sarah. My name is Diana Connolly. I am a professor at the University at Buffalo School of Law. I'm the director of the environmental program there. I have been practicing wetlands law for decades, and I'm very excited to be here today.
Hi, nice to join you, ladies. My name is Sarah Jarboe, and I'm an environmental attorney. I practice at English Lucas Priest and Owsley in Bowling Green, Kentucky. And I have a wide range of environmental practice over a decade now. I can't say decades yet, but I'm getting there. And my practice includes Clean Water Act, Section 404 and 402. So I'm happy to be here today.
So we're going to just give you a really brief, before we get into all the current stuff, really brief background. We've got a whole bunch of state and federal statutes and rules that regulate wetlands around the country, as well as an international treaty, the Convention on Wetlands, which is just cool to know about, but not important to what we're going to be talking about today. And why do we have all these laws? We have it because wetlands are really important to the environment. And so what are these things? There's actually a formal regulatory definition, same exact definition by all the agencies that regulate it under 404. Those areas that are inundated or saturated by surface or groundwater at a frequency and duration sufficient to support, and then under normal circumstances do support, a prevalence of vegetation typically adapted for life in saturated soil conditions. Now that's a long explanation. So basically you're looking for places that are wet, at least sometimes, with certain soils and certain plants, and it really depends on where you are in the country as to what those types of plants and soils are. And so globally and in the U.S., we actually haven't treated these wetland areas very well. For many, many decades, we actually got rid of them. There's a very old Supreme Court case that said that it was a very good idea to drain swamps and wetlands. And so globally, we've lost a lot of wetlands. We know, however, they're important for many reasons. And so we have regulations, but there's a balance because there's a need to use some of these lands for other various human needs. So that's where we get into a lot of these debates. Way back in the day, there was a confusion after this thing called the Environmental Protection Agency was created and this new law, the Clean Water Act, was passed as to what was going to happen on a federal level with these lands. And so that eventually ended up in a district court case that dealt with this, that said, go forth and regulate wetlands and waters very far. So after this case came out, there was a lot of decisions that were being made at a local level in D.C. about how to regulate these wetlands and what these things were called under the Clean Water Act, which is navigable waters. And the definition of navigable waters was waters of the United States. And they were regulated by two agencies, the Corps of Engineers, doing most of the permitting, and EPA helping with the permitting, but taking the lead on all sorts of enforcement and other actions. And they were still trying to figure out how far they were to go. And then there was a series of decisions that eventually ended up with a unanimous Supreme Court decision in 1985, Riverside Bayview Homes, saying that there should be regulation as far as the Commerce Clause allowed. So at that point, the EPA and the Corps issued some rules defining waters of the United States, these navigable waters, to all sorts of waters, including interstate wetlands and wetlands that were adjacent to other waters of the United States. And the definition that was in there in these regulations, sometimes referred to as the migratory bird rule, is anything that could affect interstate or foreign commerce. So lots of debate happened as to how that should be interpreted, whether that was too far, for a long time after those regulations came out, that eventually ended up in a decision from the Supreme Court in 2001 in Solid Waste Authority of Northern Cook County versus the Army Corps of Engineers. And it said there's a limit. It's no longer as broad as it was under Riverside Bayview. And it opened up a vigorous legal debate that has now spanned decades. And so let's discuss kind of what's happening under this, and kind of starting with the first case that came after this, what we call the Swank case, the Rapanos case. I actually was an author of one of the amicus briefs in the Rapanos case. But Susan, can you just kind of start us out on what happened, brief history of the regulation of wetlands, starting with Rapanos?
Sure. Well, 5 years after Swank was decided, the Supreme Court came out with yet another decision on that scope of what is included under the jurisdiction of the Clean Water Act. And so in Rapanos versus United States, that involved, we had a landowner with wetlands on their property that they cleared that were adjacent to various intermittent drainage ditch through multiple conduits down to a navigable, in fact, waterway that was several miles away that eventually emptied into Lake Huron. And so they ended up with the reversal of the Sixth Circuit decision that upheld jurisdiction based on essentially any hydrologic connection to a traditional navigable water, no matter how slight, was a basis for Clean Water Act jurisdiction, according to the Sixth Circuit. And the Supreme Court said, whoa, that is way too far. And they reversed it, but they got there in a curious way. They had a plurality decision where 5 of the 9 justices ruled that the Corps had gone too far and Sixth Circuit's test was too broad, and they could not base jurisdiction solely on whether there was a hydrologic connection, no matter how slight. But they split on why and the how. So Justice Scalia wrote the 4-member plurality decision, and that limited the jurisdiction on those waterways that connect down to a traditional navigable waterway. It said only those waterways that have a relatively permanent standing or continuously flowing, only those that are such bodies of water that are commonly recognized as streams, oceans, rivers, and lakes. Those sorts of things, they have that connection to a traditionally navigable water, those can be regulated as waters of the United States. And in addition to that, the wetlands that are, as a practical matter, indistinguishable from them can also be regulated. And that occurs when the wetlands have a continuous surface connection to a water of the United States, such that there is no clear demarcation between waters and wetlands. Now, all this language is going to sound very familiar to the Sackett decision we're going to talk about in a little bit. But that plurality test, written by 4 of the 9 justices, became the so-called relatively permanent water, or RPW test. Justice Kennedy concurred in that, but had a different basis. And under that basis, he called it a so-called significant nexus test, as it came to be known, saying the government can regulate a wetland or a water as long as it alone or in combination with similarly situated waters significantly affects a navigable, in fact, waterway. And they specifically said that excludes remote drains, ditches, and streams with insubstantial flows and only speculative evidence of significant nexus. So as you might imagine, that created sort of a disarray for the agencies going forward. So,
that was exactly what was happening. That people had no idea. The regulated community had no idea. Other people had no idea. And in fact, a lot of us who were trying to help the regulated community and other people who cared about wetlands figure out what was going on, turned to scientists, and they're like, we don't know what this means either. So there was just a lot of head scratching. And so there was a lot of conferences that were exploring that right away. So then in this confusion, how did the Corps and EPA respond to this decision?
Well, they convened a scientific group to actually try and figure out what was a significant nexus. And there was a whole, paper that came out of that decision and fed into some of the rules that Sarah will be talking about a little later in our program. But initially, in response to Rapanos, they came up with multiple guidance. And because of the Supreme Court's decision in Marks versus United States, which said when you have a plurality decision, you have to go with the ruling that represents a concurrence on the narrowest ground, they decided that, or most courts that looked at it decided that the significant nexus test was a test that controlled because the relatively permanent water test was a subset of that test. So because the significant nexus was a broader scope of jurisdiction, that was the one in which most of 5 of the justices would agree there was jurisdiction because the relatively permanent waters were a subset. So they came up with guidance that applied both of those tests. They had a lot of evidence that you had to meet if you were going to claim jurisdiction because it was a relatively permanent water or adjacent to a relatively permanent water, and a whole lot of cases on a whole line of guidance on how to establish a significant nexus. And that they came out with in 2008, amended it in 2009, and that's what everyone was working up until they finally got around to additional rulemaking several years later.
And there were a lot of court cases that were kind of continuing to muddy this water that were coming out during this time. So in this effort to kind of clarify what the ruling meant and how the regulated community should respond to it, recent administrations attempted to codify the Rapanos decision. And Sarah, can you help us understand what those proposals did?
Sure. So those attempts start in 2015 when the Obama administration promulgated the Clean Water Rule. And that rule asserted jurisdiction under both the Scalia relatively permanent test and the Kennedy significant nexus test. Now, that rule never actually went into effect because of court challenges. So we had the rule, it was being heavily litigated. And then in 2019, the Trump administration was in office. They withdrew that clean water rule. And the next year, they came out with their own version of a waters of the U.S. definition that was referred to as the Navigable Waters Protection Rule. And it went back to just the Scalia relatively permanent water test. Again, heavily challenged in court. So it was in effect briefly and then stayed by court challenges. It was even reversed. It was vacated and sent back to EPA in 2021 by the Arizona District Court. And after that, EPA decided to halt implementation nationwide. The next step was by the Biden administration, and they took their shot at a definition of waters of the U.S. in 2023. And that was the revised definition of waters of the U.S. rule. They, similar to the Obama rule, went back to asserting jurisdiction under both Rapanos tests. Same story, quickly challenged in court. And those challenges, there was one in the Southern District of Texas. That was a suit brought by Texas, Idaho, and industry groups. There was a suit brought in the District of North Dakota by a coalition of 24 states. And both of those courts granted preliminary injunctions. So the 2023 rule in 26 states never went into effect. There was a third piece of litigation in the Eastern District of Kentucky that joined 2 cases, one by the Commonwealth of Kentucky and another by the U.S. Chamber of Commerce, Kentucky Chamber of Commerce, and industry groups. And this case proceeded on a different track than the Texas and North Dakota cases. In the Eastern District of Kentucky, the district court actually sua sponte dismissed for lack of standing, and that immediately went up on appeal to the Sixth Circuit, which issued a stay pending appeal. That's when you added to the stay Kentucky, so the 2023 rule was not in effect in Kentucky or for the plaintiff's members in that case. There were a lot of attempts, a lot of back and forth on the definition of waters of the U.S., and ultimately you ended up each time with a patchwork map of what rule was in effect where.
Yes. No, it's been fascinating. And I just want to add a personal note in here. which is the Swank case came out, the solid waste case came out when I was pregnant with my daughter. And then the Rapanos case, when I was working on it, my son was very little. So I've watched my kids, and now at this point, we're still having similar discussions, and both of my children are in college. So this has been quite a part of my career as well as a part of my life when I think about my kids. But let's now turn to where we are today, the Supreme Court's 2023 decision in Sackett. And Susan, can you just start us out with kind of getting us resituated back with the facts that were in Sackett and how the majority ruled?
I think the facts in Sackett are really instructive here because you recall in Rapanos, that was a long way down to the navigable, in fact, waterway and thence to Lake Huron, quite a distance through multiple conduits. Here, the connection was much, much closer. If you see a visual image of the Sackett property, Michael and Chantel Sackett had property near Priest Lake in Idaho, and that's an intrastate navigable lake. And they backfilled the wetlands on their property, and the Corps and EPA brought an enforcement action against them. And in that case, the wetlands were separated from Priest Lake only by a road and a roadside ditch. And then pretty much there you were. There was the lake. There really wasn't much differentiation. The road is only 30 feet wide. It wasn't even like a 6-lane road or anything of that nature. And they claimed jurisdiction under the significant nexus test by virtue of that roadside ditch that led into a non-navigable creek which ran into Priest Lake. And the distance was much, much closer than Rapanos, yet all of the justices agreed that there was no jurisdiction over the wetlands, that they were not adjacent wetlands, and that significant nexus did not apply here, but they got there in various different ways. All of them agreed that they were not jurisdictional, but the majority really leaned into the Rapanos relatively permanent water and adjacent wetland test. And unfortunately, they left us a little bit in the dark on any nuances they would place on the relatively permanent water component of the test, because they could have taken the opportunity, because it was a roadside ditch, to elucidate what they meant by relatively permanent water, but they really didn't take that opportunity, something that Justice Thomas recognized in his concurring opinion, but that they really kind of really didn't address. They focused on the wetlands, and they said, again, waters means geographic features that are described in the ordinary parlance as streams, oceans, rivers, and lakes, and that the use of the word navigable means that term is important in the plural. So you have to look at wetlands in the context of their relation to those waters. And therefore, Clean Water Act jurisdiction only extends to wetlands that are, as a practical matter, indistinguishable from other waters in the ordinary parlance that are themselves waters of the United States. And that's where the relatively permanent water aspect comes in, where they're not themselves traditionally navigable waters or tidal waters that are a separate category of jurisdiction. So the waters that are relatively permanent, continuously flowing, or standing waterways that connect to a traditional interstate navigable water. And they threw the word interstate in there, but then really didn't talk about Priest Lake being intrastate, which is another interesting aspect. Those are the waters that the wetlands must be adjacent to. And they focused on adjacency as a practical matter indistinguishable, meaning that it has to have a continuous surface connection with that other WOTUS, making it difficult to determine where the water ends and the wetland begins. Now, they conceded that the only time they conceded where it didn't have to be directly connected, practically indistinguishable, is in a footnote they dropped and conceded that someone could not illegally construct a berm or another feature that separated the wetland from a relatively permanent water or traditional navigable water, that those would still be jurisdictional with that illegal feature. But they did state that a legally constructed berm would sever jurisdiction. They stated that very clearly in the footnote. So those are the situations where we find ourselves in the majority decision in Rapanos, and that was the test that the Biden administration was faced with
Right.
in having to conform their rule to.
That was very helpful. And I'm just going to go back just for a minute for assuming a lot of the people who might listen to this are really familiar with these terms. I just am wondering about the people who aren't familiar with these terms. I just want to go back to saying we've got the Clean Water Act. The Clean Water Act regulates these things called navigable waters, and they define navigable waters as waters of the United States, which is part of why this is so confusing, because this is an old definition that we're still trying to figure out what they meant, and there's never been an amendment to the Clean Water Act. And so when we talk about this term called jurisdictional waters, it means, are these waters subject under the Federal Clean Water Act to the jurisdiction of the United States? So waters of the United States and jurisdictional waters means things that the federal government can regulate. And that's where this fight is about. We're going to hear a little bit later, but I want to just bring up that states can still regulate, and many states do regulate wetlands. So the jurisdiction is about federal.
And to that point, to bring it back, if a wetland is jurisdictional under the Clean Water Act, you must obtain, absent very narrow subset of exemptions, you must obtain some sort of authorization, be it a general permit, and a nationwide permit, an individual permit. You must obtain authorization from the federal government, from the Army Corps, to discharge dredged or fill material into that wetland. And as a practical matter, that means any activity in the wetland. There are a lot of nuances we won't get into on this podcast, but as a general matter, if you're going to fill it for a parking lot for any purpose, you're going to need a permit to do that. And even though it's called a discharge of, it really means if you're filling it, if you're disturbing it, it's likely going to require a permit if it is jurisdictional. And that's what all the fighting has been about.
That's what we've been fighting about for decades now. So anyways, here we go. So you mentioned that the Biden administration was faced with figuring this out. So what did the Biden administration do through EPA and the Corps? Because that's how the administration acts. It acts through its agencies. What was its response to this decision, Sarah?
Well, they had to come up with a response. There was no doubt that the 2023 definition of waters of the U.S. that the agency had promulgated was inconsistent with Sackett, just on its face. It couldn't stand on its own after the Supreme Court issued the Sackett decision. So what EPA did was, instead of repealing the 2020 rule, it issued the conforming rule. And that was really just an amendment to the 2023 rule. It deleted text from that rule and added a little bit of text. So we, in the industry and the field, we call that the conforming rule generally. So what it did was it deleted all references to the significant nexus standard. Those provisions were clearly invalid under the Sackett decision. It removed the provision for assessment of streams and wetlands under the additional waters provision of paragraph A5 of the rule. And that's because any jurisdictional streams and wetlands were covered under paragraphs A1 through 4. The conforming rule struck interstate wetlands from the 2023 rule because under Sackett, as Susan just explained, a wetland cannot be jurisdictional merely because it is interstate. There's more to it than that. And the one addition that the conforming rule makes is that it does give a definition of the term adjacent.
And I would just point out that just as an example of that interstate wetland, you might think, of course that's not going to be jurisdictional. Okefenokee Swamp that straddles the Georgia and Florida line is a massive wetland, but that was jurisdictional because it is interstate wetland. And so it would not, just on that basis alone, it would not be jurisdictional for that reason.
So here we are. We've got litigation that's out there pending about challenging the 2023 Biden rule. And then we've got the conforming rule coming out. And so what impact did all this have on all of the litigation that's out there, Sarah?
The litigation continues on. In Texas and North Dakota, where that stands as of October 2nd, which is the day we're recording this podcast, is that summary judgment briefings are done or are very close to being done. There have been some SIR replies and additional briefing going on. We don't have any decision from the courts yet, because that's all been wrapped up pretty recently here. But what they did when the conforming rule came out is, in those cases, they amended their complaints to sweep in the conforming rule. And they did that because they weren't happy with the conforming rule for several reasons. And all of the reasons have to do with either the conforming rule not being consistent with Sackett, or asserting that the rule was vague and leaves room for the agencies, the Corps and the EPA, to interpret the rule inconsistently with Sackett. I'll just give a few examples of the issues that are being asserted in the litigation with the conforming rule. The interstate waters provision. The conforming rule maintained that provision as categorically jurisdictional. Now, that's interstate waters. We were just talking about interstate wetlands. A little distinction there. The conforming rule says interstate waters categorically jurisdictional. That is arguably inconsistent with Sackett's description of waters of the U.S. as a relatively permanent body of water connected to traditional interstate navigable waters. So the question there is there Clean Water Act jurisdiction over a body of water simply because it's interstate, even when it's not connected to a traditionally navigable water? There are similar questions being raised in the litigation concerning impoundments and tributaries. Those categories are maintained in the rule, and the question is, how do those impoundments and tributaries have to be connected to traditional interstate navigable waters? And one other thing that I think is interesting that comes up in the litigation is that when the conforming rule was issued, there's a relatively short preamble that comes along with it. And it provides a short explanation of why they're issuing the conforming rule and that they're doing it to be consistent with Sackett. But in comparison, the 2023 rule that came out had a very extensive preamble. And the conforming rule doesn't address that preamble. It doesn't go into detail or explanation or guidance on how some of the provisions will be interpreted by the agency. And that's where the plaintiffs in the litigation are saying, look, maybe on its face, the conforming rule is not egregious, is not that far off from Sackett. But when you are looking at it in the context of the long history of guidance, in the context of the preamble to the 2023 rule, which was not clarified with the conforming rule, there's just too much room for agency interpretation and to get off track from the Sackett decision. So that's the status of Texas and North Dakota. In the Eastern District of Kentucky case, that is also ongoing. I mentioned that it was up on appeal to the Sixth Circuit. The Sixth Circuit in July of 24 reversed the lower court decision, said you shouldn't have sua sponte dismissed this case. The mandate was issued on September 23rd of 2024 that vacated the lower court's decision, remanded it for further proceedings. And when it did that, the stay order was lifted because that was a stay pending appeal. So again, as of October 2nd, the 2023 conforming rule has gone into effect in Kentucky and for the plaintiffs and their members.
Thanks for all that, Sarah. So Susan, can you help listeners understand by summarizing what's happening in the 26 states where the original Biden rule was stayed?
Well, as Sarah pointed out, we are sort of in a fluid situation with the court's rulings and telling the states that were the plaintiffs in this litigation that the rule with the conforming rule now does apply to them. But up until this point, we'd had the 26 states that were part of this litigation were subject to what EPA and the Corps were calling the pre-2015 rule and implementing guidance as interpreted by the lens of Sackett. And the conforming rule with the Biden, both of the rules, I guess I'd call them, were being implemented in the other states. Well, as a practical matter, there was really no differentiation between the two. In last fall, they issued a slide deck to the tribes and states on how to interpret both the conforming rule and the pre-2015 regulatory regime for both categories of states. But as a practical matter, as I'll discuss a little later, the field memoranda that are coming out from headquarters on this subject from both agencies, the joint memorandum, are really mixing both, and they're using the same interpretations in both the states that were parties to this litigation and the states that were not. So really the same jurisdictional tests are being applied across the board.
So it's early days, but can you give listeners a sense of how the courts are interpreting Sackett so far?
Oh, yeah, we have 3 court decisions I want to talk about on this podcast, although more kind of trickling in various preliminary stages. One is the only appellate court case that has come out, and that came out in December of 2023, Lewis versus United States. And that was a multi-year struggle of his property owner challenging various jurisdictional determinations the Corps made on its property. And ultimately, the court held that there was no jurisdiction over the wetlands. They were not adjacent wetlands because the nearest relatively permanent body of water was removed miles away by the subject property by roadside ditches, a culvert, and a non-relatively permanent tributary, meaning that it was not difficult to determine, quote, where the water ends and any wetlands on the property begins. There's simply no connection whatsoever. And the surface flow path went through ditches, culverts, a non-relatively permanent water to a relatively permanent water several miles away, and then ultimately to a traditional navigable water 10 to 15 miles away. And the court said that was far too attenuated. The court tried to pull back its last approved jurisdictional determination and make the court's case moot and let them try again. And the court said, no, there is absolutely no basis for jurisdiction here. And they focused on really the difficult to determine where the water ends and wetland begins aspect of it, and not the fact that there was a long attenuated hydrologic connection. Again, it kind of focused on the fact that it is a fact-specific determination. And so I think that's something that we do need to keep in mind here is this is a very fact-specific evaluation. The Glenn Environmental Coalition case versus Sea Acquisition South District, Georgia case came out in March of 2024, and that came out of a citizen's suit for enforcement for the filling of a wetland near Dunbar Creek in Georgia. And I reference this is on appeal to the 11th Circuit case, so we will have an appellate decision on this one shortly, so this one is definitely something to keep an eye on as well. And in that case, despite expert affidavits saying the wetland was directly connected via surface runoff and groundwater through culverts and pipes, the court said that was not sufficient to demonstrate that the wetlands had a continuous surface connection with Dunbar Creek, which was a relatively permanent water. And in that case, what the court appeared to focus on was photos that the court reviewed established what it called a clear demarcation between the wetlands and the relatively permanent water. But unlike Lewis, I would point out that in this case, where in Lewis, there was several miles of separation. In Glenn, it was hundreds of feet. In that case, it was more along the line of the Sackett facts, where it was the Dunbar Creek was separated by a salt marsh, a road, a median, the other side of the road, and then finally the subject wetlands on the property. In that case, they found, again, there was not a continuous surface connection. Now, turning to the White versus EPA case, a case that EPA and the Corps have really leaned into in their recent field memorandum, is an East District of North Carolina case that came out in June of 2024. And that was specifically in response to a request for preliminary injunction to enjoin the conforming rule. And the basis for that request for preliminary injunction was the fact that it did not include the practically indistinguishable from the waters of the United States, such that it is difficult to determine where the water ends and the wetland begins. That is what the plaintiff sought to have added to the definition, and they said it was important. The court denied that injunction and said that the phrase, as a practical matter, indistinguishable prong is met when the continuous surface water connection test is met. In other words, and this is a quote, put another way, a wetland with a continuous surface connection is a water of the United States because that continuous surface connection renders the water practically indistinguishable from the jurisdictional water to which it is connected. The continuous surface connection powers the test. And I have to say, once this decision came out, that language started showing up in all of the field memoranda coming out from June onward, interpreting the rule. I think that's a significant finding of the court that the agencies are relying on, in contrast to the Glenn and Lewis decisions, which really kind of did focus on the fact that the connections were not relatively permanent water.
So, Sarah, we've got a lot of uncertainty here. And we've got good people who are working in the Corps district offices as federal employees who take the lead on permitting and jurisdictional determination. So how are they navigating the situation that's facing them?
The Corps and EPA came up with a process to coordinate their responses on draft approved jurisdictional determinations. As Susan mentioned, these are very fact specific. They're case by case. And what we started seeing starting in September 2023 was the Corps and EPA putting out guidance to the regulated community saying, okay, here's how we're going to figure out these fact-specific situations moving forward, just process-wise between the two agencies. And so for listeners who are trying to determine what is the current process, I thought it might be helpful to just walk through briefly the series of memos that have been issued, because there are quite a few. As I mentioned, it started in September of 2023. There were 2 memos issued, and they're called joint coordination memos. One was for situations in which the conforming rule applied, and the second joint coordination memo was for the pre-2015 regulatory regime. They issued a coordination process update in April of 2024 and another more recently in August of 2024. And then you'll also see there are extensions of the joint coordination memos, and those simply extend the effectiveness of the joint coordination process. And right now, those are effective until March of 2025. So as of August 2024, here's how the agencies say they are handling draft approved jurisdictional determinations. When those decisions address wetlands under paragraph A4, and those are the adjacent wetlands questions, and under the category of A5, which are intrastate lakes and ponds, all of those are being coordinated, the agencies say, at the local level. And what they mean by local level is between the Corps district and the EPA region. Where the pre-2015 regulatory regime applies, when the draft approved jurisdictional determination assesses wetlands under paragraph A7, And again, those are the adjacent wetlands. And under paragraph A3, those are the other waters. Under the 1986 regulations, those are also being coordinated at the local level. So basically, where you've got those two types of waters at issue in a jurisdictional determination, they say the Corps and the EPA are going to coordinate on their response on that. But they can elevate that at any time to headquarters level. That means EPA headquarters. And even for waters that are outside of those categories, the agencies can choose to coordinate at any time, and they can choose to elevate it to headquarters at any time. So it leaves a lot of discretion to the agencies on what they're going to coordinate on and whether it will be elevated up to headquarters or not. But generally, what you are going to see is a lot more input from EPA on approved jurisdictional determinations than what we've seen in the past.
Yes, elevation decisions used to be very infrequent back in the olden days. And now it's just there's a lot of elevation, there's a lot of discourse going on, and so there's a lot of concern about efficiency as well. So Susan, is the Corps putting out any guidance that's going to help the regulated communities and others who are interested in wetland regulation figure out how to proceed?
They are putting out guidance. I don't know that the regulated community are going to like the guidance they're putting out, but it should at least illuminate some facets of how they're interpreting it. In all of the field memos since June, the agencies are stating that indistinguishable is not a separate element of the continuous surface connection test. They're reading out the phrase so that the wetland is, as a practical matter, indistinguishable from the adjacent WOTUS, right? They're reading that out of the test. They focus instead on whether there is a continuous surface connection via some sort of unobstructed physical connection. And it's a very fact-specific determination on what they're looking at. Channel, bed and banks. They have issued field memoranda claiming jurisdiction despite the connection being via a non-relatively permanent ditch, an ephemeral ditch powered only by rainwater. As long as they were able to find evidence of flow and flow characteristics, they say the presence of flow is helpful but not required in that connection. So there's a distinction between a continuous surface connection is something less than relatively permanent water. So something can have not be jurisdictional in itself, a ephemeral stream, for example, yet the upstream wetland could potentially be considered jurisdictional. You could end up with a situation where you fill in the wetland and you have to get a permit. But if you fill in the stream, you wouldn't have to get a permit. So that is an interesting conundrum in how they're interpreting these rules to basically create separate tests for continuous surface connection and relatively permanent water. Because the relatively permanent water, the Ragsdale case that was also post-Sackett, makes it very clear ephemeral and intermittent streams are not relatively permanent water. They have to have more than that level of flow. As we all know, flow is a very difficult test, which is why it's just a fact-specific evaluation. This test is necessarily going to be fact-specific. But I think that is an interesting conundrum that they're faced with that I think, is something that someone is going to challenge. I'd say someone is going to challenge the fact that although they have not said it expressly, they've certainly made it very clear that a connection can be via a non-relatively permanent ditch, culvert, etc. Now, they have focused on how long the connection is, but again, it's very vague. How long is too long? They said 350 feet is long enough. Hundreds of feet are long enough. Whether they get to miles, they may say it's not long enough. So I think those are some very important guidance memos that everyone should be aware of. We are going to include a link to those in the podcast description. You will see it when you link and try and watch this podcast. You will see that link, and that takes you right to the Corps' webpage where you can find all of those field memoranda, and they will be adding to those as more things get elevated pursuant to those memoranda that Sarah mentioned.
Susan, you mentioned that the Sackett decision expressly says that if there's a legally constructed berm that separates a wetland from a traditionally navigable water, that doesn't count as adjacent to the navigable water. And so it strikes me in the field memoranda that you're just describing, where you could have a non-jurisdictional conduit that links a wetland, which would be jurisdictional under the agency's interpretations, that it leads to, I don't want to say gamesmanship, but because it would be a legal, reasonable interpretation that whoever's being regulated, they could fill in that conduit legally without requiring a permit, and then they would no longer have a regulated wetland that would require a permit to fill in. That just seems like an untenable position to me.
I agree, but I think that's the situation that they have built for themselves. They have claimed in multiple cases, we had, for example, considering multiple parts of a wetland to be one wetland complex, and then that wetland complex ultimately jurisdictional when the wetland was divided by roads, when there's a hydrologic connection to a culvert. They have disclaimed large subsurface connections via stormwater drain. They said that's not a continuous surface connection, but a minor subsurface connection might be. That's one of the field memoranda. But they have distinctly said swales, ditches, culverts. So any of those features that they've said are not themselves jurisdictional, they would not have jurisdiction over you filling them. Now, you might have a state requirement or an MPDS requirement that prohibits you from filling that in and blocking that hydrologic connection from some other reason, and because they did talk about the purpose of roadside culverts being to keep the hydrologic connection and maintain the flow to prevent flooding of the road and wash out of the road. So there are other legal reasons that someone might not be able to simply just block a culvert, right? But I think you definitely would have the situation we have, a non-navigable creek, which was a situation in a recent case, Ragsdale, where there's a wet weather creek that the ranch owner whose creek it was trying to say the adjacent ranch was discharging in violation of its stormwater MPDS stormwater permit and trying to get a citizen suit enforcement action against him to stop that. The court said, your creek is not a water of the United States. So it doesn't, there might be other recourse under nuisance law or other recourse against the neighboring developer, but not citizen suit action under the Clean Water Act. So I think we very much could see the situation you see, Sarah, that you could fill in that wet weather creek without a 404 permit.
So, wow, listening to all of these stories, listening to where things stand today, and knowing that the book was published this summer and we're already having to update, let's let the listeners hear what you all think the future holds for wetlands regulation after Sackett. Let's start with Sarah.
Well, it may not seem like it after listening to us on this podcast, but I really think that the jurisdiction of the Clean Water Act is more clearly defined today than ever in the history of the Act. And the Act is over 50 years old, and you've heard the debate and all the uncertainty that still exists. And I still believe we are closer today to a clear definition than we ever have been. So clearly, there's still a lot of work to be done. And really what the regulated community wants more than anything is that kind of certainty. So I think with the Sackett decision, that certainty is within reach for the first time. If Sackett is interpreted as I believe the Supreme Court intended, it would not take a consultant. It would not take a lawyer to look at a piece of land and know whether there's a jurisdictional water present. It struck me when Susan was talking about the Glenn decision, where there were expert affidavits trying to tell the court whether there was a direct connection between the wetland and a traditional navigable water. And the court, instead of relying on those expert opinions, the court looked at the photos and said, there's a clear demarcation here. I think that is the goal. I think that's what the regulated community needs and deserves, is to be able to look at a property and say, okay, if I want to develop this, if I want to build my lake house here, in the case of the Sacketts, I'm not going to need a 404 permit for this, or I am going to need a 404 permit for this. I really, and this is, maybe it's aspirational, but I hope that we get there on that certainty. We have an election coming up. And if there's a Republican administration back in office, it's very possible that certainty could come sooner rather than later. So if you see a change in administration, I think what we can expect is for the conforming rule to go away in some shape or form. The litigation that's pending, if the plaintiffs get favorable rulings from the court, a different administration may not fight those, may not appeal decisions that say, yeah, the conforming rule is not consistent with Sackett. Or they may just withdraw the conforming rule on their own. At least that's what I hope we're going to see in the future on the definition of waters of the U.S. Susan, what are your thoughts on that?
Well, I agree that if a Republican administration comes in, we're going to see a change. I would expect that the low-hanging fruit there would be to amend the conforming rule to add in the, as a practicable matter, indistinguishable language that has been read out by the White case and by the Field memorandum. I think ultimately that would be the quickest route. And ultimately, I think the courts will step in, and whether it'll go back up to the U.S. Supreme Court sooner rather than later, I can't say. But I think they will step in on that practically indistinguishable component, because I think they really did mean it. I think they really did mean something that is the edges, that you can't tell where the wetland ends and the water begins. That they intended not to mince words about whether whether it stops, at a certain depth, or whether you go out until your field indicators tell you you're not in a wetland anymore. I think that's what they meant. They clearly didn't say it, and that's clearly not the way the agencies are interpreting it. So I think we will see them try again at some point. Whether the agencies try again and do that same thing, I don't know. They have not been models of clarity up to this point, as we know in their rules, because again, it's a scientific question that they're trying to get a legal rule to encompass to make it more clear. But until we have something that is as clear as that, I don't think we've met the goal of the Sackett case, because I think that's what they wanted, is something where you could go out and say that wetland is jurisdictional or it's not. This necessarily fact-specific question is not what the Sackett court had in mind.
And so listeners are going to have to watch. And there's a lot of people in the conservation community who are thinking creatively in different ways, who have a very different vision of what the history of the Clean Water Act shows for how it should be interpreted and going forward right now. So the debate is not over. The litigation in this area is not over. The regulation in this area is not over. And that is in part due to the way that this was defined back in 72, that leaves a lot of room for this continuing debate. So, Sarah, would you want to say some final words?
Yeah, that is one area where I don't expect to see any movement is clarity from Congress on the definition. I think that Congress has been happy to sit this out and watch it play out in the agencies and in the courts. So that's one thing I don't anticipate seeing anytime soon.
And
One
as an
thing,
academic, I do not disagree with you. There has been no movement, like in other environmental laws, there's been no movement to come in and amend some of the original language.
One thing we may see movement on are more states trying to, govern their own houses, as it were, and develop their own regulations to differentiate between what is a wetland deserving of protection and what is not. Some states already have a robust regulatory program. Other states rely solely on the state or on the federal definitions, or have no program of their own other than water quality certification. And so I think there's room for growth in that area. They can always be more stringent than the federal government. They cannot be less stringent than the federal government.
It has been an absolute pleasure to spend time with you this afternoon and record this podcast again, it was recorded on October 2nd of 2024. Sarah and Susan, I'm really thankful for you. I'm really thankful to the listeners. And I would say to the listeners, please be sure to check out the materials that are going to be accompanying in a link. And as a reminder, the best place to get your copy of the second edition of the ABA Wetlands Law and Policy book is from the ABA website. Thank you all very much.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.